We've got a total of about 10 people, so we'll try to make this as conversational as possible. First, I want to thank everyone on the committee. This process has been going on for almost 2 years, and the board has put a lot of time into it over the last few months. We've had several meetings that I think stretched several hours. I don't want anyone to think that these weren't well debated and deliberated. We're going to talk through a lot of our explanations and how we got to some of our answers and frankly where we disagreed on some things along the way. The other thing I wanted to mention, this is part of a 3-part process for the board. They started 2 years ago working on the bylaws. Recently, Beth has taken the lead. A lot of things have come up over the last 6 months. We're going to probably redo a lot of the policies and procedures, some things that don't make it into the bylaws that we think are appropriate for the policies and procedures. You'll see roll out over hopefully the next couple months. And then there have been questions about the covenants. A lot of what's in the bylaws are really dictated by what's in the covenants. You can't contradict the bylaws with the covenants, but we are going to go back, probably once we get through the bylaws and start taking a harder look at the covenants and seeing how we can bring those up to date as well. Today, again, to everyone online, we're going to try to be as open and conversational as possible. The plan is that we're going to go through the document. We took all the comments online, things that were sent to us directly, other feedback. We tried to compile it on the governance task force into a list. I think we have about 23 items, some major, some minor. And we'll run through those today. Please raise your hand, ask questions, interrupt us. If we get to a part of the document that we're not addressing, please feel free to stop. And but we thought that'd be the most efficient way to work from front to back of the document and at least hit everything that we know we have on the table right now. If you're in the room, if we could ask you to step up to the podium, just so the people online can see you, and also for those that may watch the video recording later. Our goal today is to provide explanation where we can, give background on what we did, collect as much feedback from the people that are involved today, and the board's going to meet again next week, and I would think subsequently thereafter to try to bring these to a resolution. I'll also be asking a number of members on the governance task force to help me out today. I've only been involved in this for about 3 months, and there's several people that have a lot more background, and I think they'll chime in as well. So anyone have anything to add, or do we want to start rolling through the document? All right, we'll roll through the document. I think the first point is real. I've got 2 points that I'll call throughout the document. The first one I'm going to let Phil speak to, but there was a lot of discussion online as to why we didn't put out a summary document. And this goes back to before I joined the board. I remember there was a lot of debate in the board meeting in February, and it's carried on for the last several months. And I'll let Phil talk to it.
Thanks, Kevin. Excuse me. We kept seeing comments come in about where's the summary, it's hard to read. And we talked about it, and interesting enough, recently my wife found this disc from 2004 that they gave us when we bought our house, and on that was actually a summary of the covenants. And so I looked at that this morning or last night and realized I see what people have done. One of the issues we've always had, you can put caveats on there, this does not bind you, you have to go to the actual document for binding information, etc. But the risk we have of putting a summary in there is that we may say something that conflicts with the bylaws. And if we've done that, we create a conundrum, at least in terms of legalities of what somebody may challenge us on. And so we felt it was risky to put that together. And this document's not that long. I know maybe it's very boring to most people, but for nerds like me, it's actually kind of interesting. But it's putting a summary in on a 20-something page document is sort of begs the question, is it really summarizing what's in there? Most of the things in there are very straightforward and they're easy to understand. And we're hoping today, by going through it, we'll be able to explain things and people have a better understanding. But I still want to stress that we think there's a risk. We in the task force felt there was a risk of putting a summary together that could potentially conflict with it. And that would just create a problem for us down the road. Anybody have any questions? Or?
I'll highlight that, I mean, we'll acknowledge that Preserve KICA, a group of members, did put together an analysis as well. Right. I've reviewed it in detail. I think it was well done. I think we used some of that feedback to put into these questions we're going to discuss today. So we're hoping that between what we did today, the bylaws themselves, and the work of some of the members, that we've gotten enough information out there for people to understand what we're looking to change.
Anything else online?
The second, Ellen, let us know if anyone puts their hand up along the way. Feel free to interrupt. The second kind of global issue is we got a lot of questions about various parts of the documents regarding the rights of the Type E member. The Type E member's rights and responsibilities are all in the covenants. They're not governed through the bylaws. So it's really not something we can address in the bylaws. It's not something we can change to the bylaws. And it's just, frankly, something we're unable to affect, and we just skipped over that. So we got a lot of different questions. Rather than answer each question, I'll just say globally, Type E member, the board member that's appointed by the developer is not something that is affected in the bylaws. Questions? Please stop me if anyone has any, please.
Ms. Hagenhart, 512 Ruddy Turnstone. My question is exactly about that, and maybe it is. However, in the bylaws, basically the Type E director, the company appointed director, is not subject to conflict of interest statement or anything else and compensation, which are provided in the bylaw, saying that directors cannot be compensated except the company appointed director, the Type E. So two very important things: conflict of interest and compensation. The company appointed director may be compensated and can have a conflict of interest, but apparently the board can't question that. That seems.
Let's go through that language, because we actually debated this quite a bit, and we do have something that does affect the Type E member, and I think I'm looking for it right now.
Ivan, let me, if you're talking about the compensation part, is an E-member must be an employee or work for the developer. So he is a compensated person, and that's in the covenant. That's not regulated by the bylaws. I mean, he must be an employee. It says clearly, right? It must be an employee or related or consultant.
I understand that.
Or employed by.
It can be construed to say that they can be compensated by somebody else for work on the board, or they can be compensated by the board. So it's not clear.
Hey, Kelly, I think we got cut off somehow, unless, oh, there we go, okay.
Be back.
Let me jump to the conflict of interest. So I'm in section 13. It's on page 15. It's item 7. And it says, director conflicts of the Type B director should be additionally evaluated as if the director. So for purposes of this document, the Type E director is a director, and everything that applies to a director applies to the Type B in addition to this item 7. Does that answer your question, or do you think that's insufficient, or?
I mean, I saw wording in there that seems to be contrary to that.
Maybe it would help me understand your question if the language that you saw that you thought exempted the Type E director, because all of the conflict of interest provisions do apply to the Type E director, but then we had to deal with the additional issues that there's a potential conflict that comes from them working for the developer also.
Yeah, so the Type E actually has more I guess more opportunity for conflict.
I think they jumped out again.
We haven't gotten that, but we're on it. We can cover it. We'll just skip over it later, please.
Really different there. Fairway Oaks. That's my biggest concern here is number D. Throughout this whole document.
I'm sorry, what page are
13, D.
Page 13 or section 13?
Page 14, conflict of interest, number D.
The director shall recuse himself. Okay.
Should. Throughout the whole document, shall is used, which has a legal connotation. In this sentence, should is used, which does not have a legal connotation and does not obligate the person to recuse themselves. It's up to them.
So
It should be shall.
we debated that, and we actually do think it should be should, and I'll tell you why. There was actually a lot of email traffic and people talking about that over last weekend. It should recuse themselves. Do they have to leave the room? Do they have to stay out of the conversation? But the way this reads now, and I guess the way it was decided, is that the director should, but does not have to recuse themselves. They could continue to participate in the conversation, to advocate their position, I guess to speak on behalf of the developer in some cases, but their vote shall not be counted.
Should they even vote?
Yeah, I guess.
Should not be able to vote. They
Well, but it won't be counted.
Yeah, I guess that's language. I mean, then we can turn that around, but if they can vote, but it won't be counted. So, is that right or wrong? I guess it's open to debate, but I think most people came down when they looked at other examples of this type of language, was that in this case, they should, but they don't have to step out of the conversation, but in no way does their vote count.
If you abstain, you're voting. You could, so an abstention is a vote as well.
Well, it wouldn't count.
It wouldn't count, but it was an abstention, he abstained himself, so. I mean, a regular director can abstain himself too as well.
okay.
In this case,
I see.
but it says shall not be counted.
Jim, did you want to add anything? We talked about, when we got farther down the list, you were going to address that. Did we question that well, or?
Yeah, no, I think that's fine. You did fine.
That's a good question.
Kevin, can you hear me?
Yes.
Yeah, my point on that is that the value of that person with a potential conflict to stay in the conversation is important, because if we're voting on something where there's a conflict, their input might be necessary for everybody else to come up with a valid vote. So I think the should abstain is okay, and the vote shall not count covers that. So I think what we have is proper.
This doesn't apply to the, applies to any director.
Yes.
Any director without a conflict. He participates in the discussion, but his vote will not count.
Please.
Again, under Section 8 compensation, it says, in addition, elected directors are prohibited from soliciting or accepting any compensation, gratuity, or other remuneration which would improperly influence or would appear to a reasonable person to improperly influence their decisions, or would result or would appear to a reasonable person to result in a conflict of interest. But it doesn't say anything about type E director. So if you're saying that the type E directors are subject to that, which is the elected directors, this basically doesn't say that.
So you're saying we should take out the word elected?
Yeah.
You can't do that. You can't do that.
Can't do it.
See, so we have a problem, in my opinion.
Well, I think that the conflict, that's limited to compensation, which we just, as we stated, the type E member is compensated by the developer. So you need to exclude that, but that doesn't exclude every other possible conflict of interest. And that's what the conflict of interest section covers. So the only one is compensation that's exculpated by that particular language.
And we have two right.
We cut out again?
Yeah, we got frozen out again. They must be talking about something important.
Okay, can you guys hear me?
Yeah,
We are losing audio periodically, just so you'll know. It's kind of spotty. So I wanted to go back to the issue of the covenants. So I think it's very important. This is a very difficult and arduous task, and I have complimented the committee publicly, and will do it again for the effort. But I would like to know if this committee, if this task force is planning to formally recommend to the board that the term and mandate of this task force be extended at the time the new bylaws are presented.
So that would be a board decision.
That's not my question, Kevin. My question is, will the task force recommend with a revised mandate that the governance task force be extended?
Well, I will bring that up at the next meeting.
Kevin, I don't think there's any limit on it, because when we originally voted to have this task force, they were tasked with doing both the bylaws and the covenants. And when they started, they realized that that was going to be an overwhelming task. They had to pick one first. So I don't think it needs an extension.
It may not. We've had a couple people resign after the bylaws are passed. I think what I was planning to do is either in July or September, bring it back up at the board, re-up the mandates, we're all on the same page, put out applications, possibly add several additional people. And then David brought up, I think last month's meeting, that the covenants were next on the list, and we addressed it at the beginning. I think that's a great idea. I can't say that we officially have that mandate today from the board.
And Paul, this is Phil Ungaro. I was just going to say, we really haven't discussed that kind of detail on the transition and how things move forward. We've all recognized covenants would come next. We also recognize there's a policy document, the governance document we have to work on. And we also recognize we may end up in a year circling back on the bylaws on some things. We just know there's going to be continuing effort. How that works has not been really talked about among ourselves.
Yeah, if you want a recommendation, we will bring that up at our next meeting and we can.
Okay, well, I have formally recommended it in my written comments. I just think that in the best of circumstances, this is a difficult, understandably difficult process. I would hate for there to be an unintended gap of, a month, a quarter, a year before the board actually decides on a revised committee mandate and extension. That's my only point, and I hope that you will consider that as part of your recommendation to the board when you get there.
Well, one of the things I'd like to say is the board is looking at changes to the covenants independent of this task force. Things that will obviously, in order to change the covenants, we need a vote of the community. There are certain items in there that the board might move forward on this year, get it in the election cycle.
Fair enough.
There may be more coming up after that when the committee gets involved. But the board on its own, I believe, and I've talked to other board members, that we might have one or two items coming up in this next election cycle.
Okay, great. Thank you.
Okay. 6, which are definitions, and some of these are pretty straightforward, I think, explanations, or we don't have answers at this time, but one of them is definition of the KICA rules. I think it was Preserve KIWA that raised questions regarding the enforceability of our KICA rules and regulations. We refer to them, I think Jim counted 8 or 9, or Phil counted 8 or 9 times in the bylaws. We have that in front of outside counsel right now. There were questions in terms of how that was amended in 2000.
Yeah.
You need to bring that up as a board. It's on there and.
Sure.
We do want to make sure that when we reference KICA rules and regulations, we're referencing the appropriate enforceable rules and regulations.
Just for FYI, we lost you again for about 20 seconds of that in the middle, Kevin, but I presume everybody's happy with the explanation.
Any questions? The next question was, there were 3 on the definition of a meeting. One, someone made the comment that all KICA meetings should be video recorded. We didn't think that was appropriate for the bylaws, but we are going to suggest that it goes in the new governance policies that the board is putting together. The next one was, can a board member attend via Zoom? And the answer is yes. There is language in the definition of meeting that says a meeting shall also be conducted by conference, telephone conference, video conference, online audio, web conferencing platform. That was about everything we could think of short of AI. So that's a yes. The next is, why is there a right to prohibit or restrict audio or video recording? Maybe that language could be expanded, but that was not aimed at members. That was really deferring to the board that I guess there was something in the past where the press had tried to show up, or maybe people are trying to use the video of our meetings in other ways, and if we felt like something was inappropriately being recorded, that the board could block that. I don't know how anyone feels about that, Phil.
Just to add to that a little bit, as you referenced, KICA does record all the meetings, and the recordings of those meetings are available. I'm not sure how you do it, but I know you can get to them. So we felt having the official recording of the meeting was the best approach for people being able to see it. And if you get somebody coming in and taking snippets from their recording and how they do it, it's not as efficient and perhaps not as.
I think that people interpreted that we were not going to record it at all, and that's not the case. There is an official recording, and that's the one that must be used. If somebody wants to use recording, they have to use the official recording of the meeting. That's really what. Right.
Questions or comments? Okay. Oh, is there a hand? The next was the definition of notice. This was small. We used the word resident, which was not defined, and we're going to change that to owner or co-owner. The next was special meeting of the members. Someone asked about, we use the terms, it shall not include, I'm going to let Jim talk to this, but it was that we block defamatory or profane language. So Jim, do you want to elaborate?
Gosh darn it, I'm going to talk about that. Sorry. Yeah, this was a clause that was actually added prior to the community release in February, but it had a different title. It was called offensive language. So the reason this appears as such a large blob of red line is because we changed the name to prohibited language, which moved its position in the alphabetical order of definitions. So the changes are not as extreme as it seems, but the purpose of this is as part of these bylaws and as part of events that happen leading up to them, it was necessary to establish a procedure for, under certain circumstances, members and dissenting directors to have access to the KICA communication channels. And that led to the discussion, well, we need to be careful if we're allowing that access to not allow defamatory or profane language, which could expose KICA to liability. So we added that clause and added a process to determine what it is. There were some questions about the timing of that process, I recall too, and the problem you run into is the process needs to be exercised in the middle of two very time-constrained sub-processes, which are the petition process, which has time limitations, and also the dissenting director process, which has time limitations. So it's important, and the petition one is driven by the covenants. You can't extend that time frame. So we needed to make sure that this process didn't interfere or delay it wasn't used to interfere with or delay the petition process. So that's why the quick turnaround is required.
Anyone see that? Keep rolling. Some of these, they get very detailed into the language. The next one is, these next two are in front of our outside counsel right now. Voting at a special meeting. Someone pointed out that the language says you have to vote ahead of the special meeting. I think in most cases, we expect a special meeting to actually be an electronic ballot. So the voting really does take place before the meeting where we announce the results of the electronic ballot and I guess ratify it. We've asked council to look at that, and it rolls into the next one where we talk about proxies and quorum. There are certain cases where you can use an electronic ballot. We found one that we'll talk about later where you specifically cannot, we believe, use an electronic ballot as the way the South Carolina statute currently reads. But we've gone back to our council and asked, in great detail, when we run a special meeting, is the voting done before or concurrent with, and more importantly, if there's a requirement that people be in person at the meeting, are proxies allowed under the South Carolina statute? So that's the big picture. That's where we are in those two items right now. I don't have a clear answer from our council yet, and we're waiting on that. And we won't push these forward until we have those answers. Does that make sense? Those aren't the easiest to explain, but anyone wants to chime in? Okay. The next one is, Jim, this is yours, talking about an action. If you have on section 8.
Right. So this, again, this is complicated to put this in context, but members have, per the covenants, members have a number of rights, obviously, to approve certain actions of the association. And this one is a little bit different. So this pertains to a board action and the member's right to object to a board action. And it's a very limited 2 sentences in the covenants that establish this right. And it talks about the fact it's very specific in saying that members only have this right if it pertains to an action of the board. And if you look later in the bylaws themselves, you'll see that we went to, and I'm looking at, let me just pull up this section here. Director votes, which is section 7. It's on page 16 of the markup version. It talks about no action shall be deemed to have been taken on any matters unless a vote or abstention of each director present is taken recorded in the minutes of the board meeting. The point being that for it to be an action of the board, it has to be a vote. So that can be a vote for something or against something, but the question a community member raised is, what about an inaction? What if the board refuses to take action on something? And our interpretation of the covenants is that this is not the avenue to object to that type of item, that what you would need to do is call a special meeting. And I won't bore you with all the distinctions between the 2 processes, but there is the ability for members to call for a special meeting if they feel the board is not taking action, i.e. voting on an item to something that they feel needs to be addressed. That's probably as clear as mud, but
Any questions or?
Brad, unmuted.
Thank you, Jim. That was my comment, and having gone back and looked at the language of Article 3 of the association covenants, I think your reading is absolutely correct with regard to only referencing an action taken rather than inaction. Just tying into the questions that Paul and others had raised about review of the covenants, I might just suggest that it would be worth looking at in the context of review of this association covenants, whether the member initiated referendum might be expanded, or whether there are substantive differences between the 2 processes you outlined, special meeting and the member initiated referendum, that might need to be, I don't know, better aligned than they are right now. But I take your point about what the limiting language is of Article 3 right now.
right. And I agree with you, Brad. That's something that should be looked at. It is sort of torture to have these different pathways for that. I will say that a no vote of the board is still an action of the board. So that should be kept in mind.
Yeah, it's a good time to reiterate, Jim. A lot of what some of the ways that this document was designed was to accommodate the covenants. The covenants are not clear, so this document reflects some of those odd processes. Is that fair?
Yes, yeah. And thank you for that comment, Brad. It was important.
Okay, no one has anything else. We're going to move on to one of the most favorite topics. Oh, please.
I know we passed by definition 2W. It states the type E member, KICA Company Limited, is a corporation duly organized and existing under the laws of the territory of the British Virgin Islands and its successors or assigns. So what happens in the case of a possible legal dispute? It says here that KICA Company exists under the laws of the BVI. What takes primary authority? I mean, we're in South Carolina. Why is it under the laws of South Carolina?
Well, they're organized out of BVI, but I think because I'm not a lawyer, but I think because we're in South Carolina, tell me if I'm wrong, it would be handled here.
They're organized in BVI, clearly, a lot of corporations are, but they have to operate under consistency with South Carolina law.
But it does say, and existing under the laws of the territory of British Virgin Islands.
Right, I think, again, not being a lawyer, I think if you wanted to question the existence of the company, you'd have to go to the BVI, but for any matter in which the company is engaging, it's under South Carolina law. So the only thing would be questioning the existence of the company that you would go to the BVI for.
It comes down to the word existence, and I am a lawyer, but existence means that's where their corporate structure comes from. That does not mean they don't have to comply with South Carolina.
As a lawyer, looked at that and said that is.
We can ask him, we can ask him to look at it again.
Just, you can say, well, no, say, well, we're under the laws of BVI, it says right here, we don't have to do that type of thing. I mean,
Paul, you have that all over the United States. Delaware is famous for that. All of the major corporations, whether it's Dow, et cetera, they're all existing under the laws of Delaware. It's the same exact language, but if they're doing business in South Carolina, they're going to abide by South Carolina law.
Anything else on where we've come up to this point? All right, so I'm going to jump into one of our favorite topics, which is elected term. I'm on Article 4, Section 3. And right now, we've had things in drafts, out of drafts. Right now, there's nothing in the draft, which means there is no current term limit language. A lot of people push for an explanation, so I'll start with mine. We debated this quite a bit at the board level. I'd say philosophically, where I came down is I don't think it's ever the job of the board to tell the members who they can and cannot vote for. So when I went back and forth with everyone else, I thought, you know what, we re-elect these people every 3 years. Is it my job today to tell someone in 10 years who they can elect for, who they can elect or who they can't? I realize that it's not popular. A lot of people are in favor of term limits. So I think I'd say most of the feedback I've gotten from the board is that we're going to completely reevaluate that, but I'm happy to hear everyone else's opinions or hear anyone else on the board speak about it.
I'll add my comment in too. When this first came out, this is a while ago when we had this one in here, my suggestion is actually the one that the task force agreed with and wrote in, that we would have term limits. There would be 2 terms with 1 year in the middle. And actually my logic was exactly what Preserve Kiowa wrote, that it would be good for incumbents to take a break. We get new people on the board without facing an incumbent, which everybody knows that could be kind of hard. So we'd still get fresh blood, but we'd still have some continuity in there. Clearly, there's an agreement on the board, although we did discuss it, and the majority of the board wanted no term limits at all. They wanted the way that Kevin mentioned. And there was 3 of us that didn't, and the task force obviously wanted what they wrote in there. So that's where we landed at this point, and that's how we got here.
Kevin, I'd like to chime in on this is because I was one of the 4 that didn't want term limits. I don't like the idea of a gap. I don't think that's appropriate. One of my concerns is many times we've had trouble getting people to run. This past election where Kevin became a board member, we had 1 seat open, we had 1 candidate. We've had situations in the past, we've had to go out and beg people to run. This year we have 3 seats going to be open. Theoretically, possibly 4, but let's assume it's 3. If we only get 2 people that want to run, we have to have a gap from sitting board members. That means we got to go in the community and beg somebody to run who probably doesn't really want to run, as opposed to a board member sitting saying, well, if nobody wants to run, I'll go for another term. So I think it's up to the community who they want to run. And if a board member is doing a great job and they want to be on the board again, fine. So if there's a limit, I don't think it should be 2 terms, but I certainly couldn't go for a gap. I think a gap doesn't do anything. People argue continuity and then they say, well, people are in there too long. And it's a fine line between the 2. So that's why I think the board 4-3 informally, voted no term limits. Let the people decide.
So David, just to make sure I'm clear, so you're changing your opinion to term limits, but no gap?
No, I'm saying I don't believe in term limits, but if we have a vote and the vote is to install term limits, I would strongly oppose a gap. I understand there's going to be a vote and I might be on the wrong side of that vote, but I can't see any reason for that gap.
Beth, thanks for saying what you did, because we did have a lot of debates on the task force about this, and we came down to a unanimous conclusion that our recommendation for the bylaw changes was to have the 2 two periods with one gap, and that was it. And we had the same discussion you all mentioned, same thing that Preserve Kiowa did. What was kind of disturbing is that the board had that conversation without our involvement, so we didn't have a chance to have interaction back and forth. And all of a sudden, we were told there would be no term limits, and we were kind of left in a conundrum. And then Kevin came in as our leader, or because Brad was off the board, and we had to start the conversation all over again. But I wanted to make it clear, the task force really strongly felt that 2 terms with 1-year gap was appropriate and important, because we do need to have new people on there.
So just to counter that, just to make sure everyone understands, when the board met, we were discussing like 20 or 30 items, trying to get through them. And as we were getting through, we agreed on a lot of items, actually, that we then made part of it. And that was one that we didn't. And so where we went as a logical next step was just to follow the process we were, that the majority of the board didn't want term limits, knowing this was not yet a final document. So totally open to the discussion on it.
Yeah. Sorry, can we also hear the other ones on the board, their opinions? What they voted, what they thought?
Look, I mean, I do believe that the institutional continuity is important. I have no, serious problem with putting a limit on, having this institutional continuity of somebody being on the board for 20 years. I have no problem. But I do believe that the gap will do damage. I think the institutional continuity is important. So limiting to 2 terms, to 3 terms, I have no problem with that. But having a 1-year gap, by the way, I don't know where the last task force recommendation was, but here's the document that went to the second opinion lawyer. By the way, we have not talked much about the second opinion lawyer that we spent $11,000 on. And it says that the recommendation by the task force was 3-year terms for directors for no more than 6 years total. That's all it said. It didn't say anything about a 1-year gap, the original recommendation. You may have changed it afterwards. And then his opinion, by the way, which we paid $11,000 for, this is no way to impose term limits on directors may have the unintended consequences of losing institutional memories, which I agree. I would rather see no limit on the years of service. If the members wish to re-elect someone every 3 years, then they should be allowed that privilege. That was the recommendation from the second opinion attorney, by the way, which nobody has talked about the second opinion attorney, which, it was very important.
So you're changing your view?
No, I'm saying,
Because you were.
I voted against, because at that time, you do have to come to agreements. It was a vote of 4-3. It was a vote of 4-3, okay? And I felt that, I have to come, I may agree with a term limitation, but at that time, I didn't see the votes for it, so I said, then, we go for no limit. But I have no problem with a limit, but not with a 1-year gap or a 3-year gap, as has been suggested. I think we would lose institutional continuity on the board, which I think is important.
2 quick responses to Alex. First of all, the
Let me finish before I forget something very important. Not long ago, 4 board members, sitting presently on the board, insisted that we need to have continuity. And they extended Jerry's term for 1 year because they said we need continuity. So let's extend the chair for 1 year. And all of a sudden, we forget about that. All of a sudden now we say, no, we shouldn't have, only a 3-year term. We should have 3 years between the 2 terms. All kinds of other things. We forget about the continuity issue that was debated here and was voted by 4-3 to have the continuity issue. So let's not forget those things, huh? People change their mind very quickly, all of a sudden. I don't understand why.
Just real
Alex,
quickly.
Phil, before you
David, I've got the chair, I think.
Hold on, we've got about 4 people. Let's go, Phil, real quick, and then she's been waiting, and then we'll cut back to David, and then we'll finish the board.
I just want to clarify 2 things. One, the version that was sent to the second set of council was not the final version that we presented to the members. That was part of the problem.
Okay. But that's the one we spent $1,000.
Well,
The second issue is for continuity purposes. It's important to understand in our minds, at least in my mind, by having staggered terms, you do have continuity because you have people staying on the board and overlapping. That's where you get continuity. You don't have to have it continued through you know, say somebody on there, like David ran for a second term, and Lord knows anybody ran for a third term in a row, I think we should have other things.
But when has that happened, David, Phil?
No, I know, but
It's
you
never
don't
happened.
have, but you
Never
don't
happened.
have with the existing board structure.
I have two things to say. One, past professional boards that I've been on, one, I'm in favor of term limits, whatever they may be. And what they did for that gap was they had an alternate board member, so that, to answer your concern, I can't see your name, but David, is that if there was an absence on the board, someone who was a board member and was on a gap year and was still interested in serving, they could be an alternate board member and fill in if there was not enough interest. They could be a fill-in, and then they could run for a permanent position the next year. And that always was a way to backfill the board. Secondly, I think past experience here on KICA is not necessarily what we'll see in the future, because there's a lot more people here and a lot more people involved, a lot more people concerned. So I think there is a lot more interest. So I think whatever you decide about term limits, whatever the numbers are, but I think there does need to be term limits. Otherwise, there's not fresh ideas, and there's more frustration, because nobody's going to run against an incumbent unless it's very antagonistic. And I think it's really important that you have some fresh blood and interaction with the board, with new people.
Kevin, I'd like to,
David, I think David was next.
I'm next.
Yeah.
All right, number one, as far as running again, and it's tough to run against an incumbent, it was very close. It wasn't tough to run against me. It was a very close election. One of the problems we have is getting people to run. The first time I ran for the board was in 2015. There was 6 people running for 3 seats. 3 went through the nominating process, 3 didn't. The 3 that didn't was Diana Mezenot, myself, and Chris Dahlstrom. We got clobbered because we weren't recommended. The 10 years prior to that election, we never had an election because the nominating committee nominated people, nobody else ran. So 10 years in a row, we didn't have elections. We had chosen members by the nominating. We got rid of that, a great idea. The first couple of years, we had 13 people running, et cetera. My concern, let's take this year for an example. We have 3 people running this year. One is running for a 2-year seat. How does this term work? It's not a full term. So is that person limited to 5 years or 8 years? So every time you turn around and you look at the pros and cons, you come up with a situation where, it's not going to work if we put too many limitations on this. I'm the only person in the history that has run for a second consecutive term. I don't see anybody who's got their head on straight is going to try for any more than that. As Phil said, you're going to have to start analyzing the psychology of somebody who wants to run for the 3rd term. So I don't see any need whatsoever for term limits, because if you got a special election to put somebody in for 1 year because somebody resigned, moved off the island, et cetera, and you have a special election, what does it mean to that person? Does he get 2 more full terms, a total of 7 years? Or is it finishing that term and he's limited to the next term? This paragraph will get to be 10 pages if you look at every possibility. Just let the public vote whoever they want to vote for.
Jim, did you have something?
yeah, I just wanted to, I think it's important that the community has context on how this came up. I mean, it's sort of an obvious matter, but when we redrafted the bylaws, I undertook to look at some other comparable bylaws out there in South Carolina. And in particular, I focused on the Hilton Head Plantation bylaws. And we had, in our existing bylaws, we have no term limits, so everybody should be clear on that. And in their bylaws, they had a provision that the bylaw, that terms were limited to 2 consecutive terms. And after that, there had to be 1 year off, but then that person was eligible to run again. So as I started looking at some other bylaws, there was either that provision, almost identical. This is other Hilton Head associations, or there was no restriction. So, and I've read a lot of articles on this across the entire country. Some states actually have statutory term limits, like Florida has a statutory term limit, but most states do not. And most HOAs do not have term limits. All that said, I think the term limits are appropriate for KICA. But I just want to be clear, the community should have context rather than thinking we shouldn't just make this up from, pull it out of thin air. There should be, you should look at what other associations, comparable associations have done and attribute some value to their thinking, that they thought through this. And as I said, the Hilton Head one had the 2-term limitation, 1 year off, but then that person was eligible to run again. So you couldn't have more than 6 consecutive years on the board. So I just want to point that out so everybody has context.
How's it going?
You have a raised hand from Jeannie Bush. Jeannie, you should be unmuted.
Thank you. What I think I'm hearing is some confusion about the gap year. I think the proposal of a lot of people is the compromise of having 2 3-year terms. And if that person wants to run again, would then take a gap year or more if you choose. But it's not a gap between the first 3-year term and the second 3-year term that I think people are, or a lot of people are advocating. It's a compromise situation. Over 84% of nonprofits do have term limits. Some allow a former elected director to run again after an interval, sitting on the bench for a year or more. But as to Dave's concern about having a hard time getting people to run, I believe that if people were not facing an incumbent, they might be more eager to run. And so I think, with the growing population and interest in corporate governance of KICA, I believe it may be more enticing for people to run if they are not constantly having to run against an incumbent. So I personally would advocate for the 2 3-year terms with a 6-year maximum, and that takes care of that special election odd situation where somebody might have a curtailed term, a year off, and eligibility then to resume for another 2 terms if desired. I do also agree that usually this will take care of itself because few people in their right minds would care for that burden for the rest of their mortal life. Thank you.
Ginny, I agree with you, but there's never been, all of the years we had troubles with people running, there were no incumbents running. The only incumbent that ever ran was me. So the history of the island is nobody ever had to run for an incumbent, run against an incumbent.
But I think those old days of the nominating committee affected that greatly. And those days are gone. And now it's more of a free market with opportunities that didn't exist before.
Yeah, I mean, I'll add, since I ran most recently, and I've gotten a lot of feedback on this from people personally, I've swung the other way. I don't like to tell the members what to do, but if we're going to tell the members what to do, I think it should be 3 on, 3 off, which I realize I'm way in the minority on that. But I think incumbent advantage is a big deal. I know when I ran, I looked to see who I might be running against. I was worried about that. And I think if they have to take multiple years off in between, I don't care how many times you run. If you can wait 5 years and get reelected and wait 3 more years and get reelected, you must be doing something right. But I think the primary thing that pushes people away from running and involving more people is the incumbent advantage, and I think a year helps. I think a 2 is better. I think it's 3 years, we're turning over the board completely every couple of years, and turning over the board, getting fresh people in, fresh eyes. I've been consistent on that on the committees, and I think it's important to the board. I know I'm in the minority on that, but that's where I'm sitting right now.
You just mentioned that the incumbent will have an advantage. When you ran, there was no incumbent, there was only one candidate. So it wasn't an issue about incumbents running, that's why people didn't run, okay?
Well, I ran 2 years ago and there were 13.
That's right, I remember that, yeah, I ran that year. When David ran, how many people ran? 8 people, I think, were that year? When he ran as an incumbent, and he didn't come in first, he came in second. He came in a close second as well, too, as he mentioned. So I don't think the incumbent advantage has rolled over people not running here, or people saying, whoa, wait a minute, the incumbent, I'm gonna sit it out. It certainly didn't happen when you ran, because there was no other candidates and there was no incumbent. So I don't believe that. I think the institutional continuity is important.
Okay, so we have hands up, and we have Jerry and Amanda who have to go, whatever order we want.
What do you guys want to speak, and then we'll take the rest of the questions? Sure.
No, take the rest of the questions. That's more important.
So Ginny, you're still unmuted if you had another question?
No, I do not.
Okay. Debbie, you are unmuted.
Okay, I'm in favor of term limits. The one thing that I would add is that if you are taking, you're finishing out somebody else's term, that you should be able to have then 2 full terms. So that I differ a little bit from Ginny and from Dave, in that you should have 2 full terms. And if you're finishing out the 1 year of somebody else's, that doesn't constitute a term. So the language could read, finishing out a term plus 2 full terms. The other issue I have had to do with just having one person running. I think only one person was running, and I think it was fine. I know of a few other people who would have run had there been more seats. Since there was only 1 seat, it made it kind of not, it wasn't as enticing for anybody to run. It might not have been the case for Kevin. That's great that we got one. And I think in the time since we've had the nominating committee, there really hasn't been as much trouble getting people to run. I think that was more of the incumbent problem, was when you had the nominating committee and people were didn't want to run. So that's where I come out, 2 full terms plus finishing up another term. And that I don't think you'd have too much trouble filling seats if it was more than 1 seat. Thanks very much. Oh, and this is Debbie Perlmutter from Sea Lavender. Sorry about that.
No one else online?
Go ahead, Amanda.
Sure.
So as Phil mentioned, as a member of the task force, I agreed with the task force's recommendation to have term limits. I don't have a strong opinion on how that's structured. I can see benefits of doing the years off or just limiting to 2. There are pluses and minuses to all of those different scenarios, but I am in favor of term limits and voted accordingly.
I try to stay neutral until the hand goes up. But my feeling is that I agree with Alex and Kevin that really folks ought to be allowed to make the decisions that they feel is in their best interest and the candidates who they think would do the best job. From a personal point of view, I think the fact that I was controversially given a second term as chair and have suffered great slings and arrows because of that, nonetheless, I feel I've grown and learned in the role. I've learned to listen a lot better. I've learned to work with our board members a lot better. And I think in my first year, struggled a little bit with that. Also, institutional knowledge and working with Shannon and her team was extremely valuable in my knowledge bank. So I'm not opposed to term limits. But I'm very much opposed to a gap. I think that is a mistake. I really think our staff needs to have some consistency with the people that they work with. I think that whoever is the chair needs to have continuity with Shannon. That's a very important part that we forget about, is working with our staff. So I do believe that people get to decide who they want to run. I'm not in favor of the argument that if you have an incumbent, that somebody's going to say, well, I'm not going to run against Jerry because he's just a director for life. And that people will run on what the issues are and what's important to people.
Kevin, you mentioned the first time you ran. The first time you ran, there were 13 candidates. No incumbents. 0 incumbents. The next time, right, when David ran, there were 8 candidates, 1 incumbent. So the issue about incumbents is not an all hindering people from running. I mean, or stopping people from running, or saying, oh, well, I don't want to get in. There hasn't been any incumbent running, and that hasn't been the issue. And in this year, there's no incumbent again, and there was only 1 candidate. So
yeah, my point was
you hamper people, or people will not, run because of incumbents. I think it's a very weak argument. We haven't seen it. We have not seen it. The history shows you it has not happened. It certainly has not happened.
Yeah, my point was the opposite. If there had been incumbents, you might not have the same people running. But does anyone else, we've been on this for a while, does anyone else have anything to add online, or please?
Regarding elections in general.
Yeah, just so they can see on the video.
I was 3 years ago when there were 13 candidates, along with you, Kevin and Alex. And the results of those elections were never really released. In other words, no numerical value was placed on what each candidate got. And I called and asked Jimmy at the time, and he said, well, you were about in the middle, maybe about 6 or 7. We put a lot of time into that. And I think some transparency there would be good, because I think that election did sour some people, I think, on running again. Did me. May not have others. I'm glad Kevin is here. But I think some transparency and actually releasing the actual results would be good. I think these revisions to the bylaws may encourage people again to get beyond this board. But I think that some good people did have some distaste at the time and what happened afterwards. Hopefully that's all behind us now, but just a suggestion that I think releasing the actual numerical value, what each candidate got, would be a good thing. And it might encourage somebody who maybe was close, or somebody who wasn't, to run or not run again. So, and I do think we will have people running after these bylaws are revised.
I agree, Doctor, but the majority of the board has disagreed with me about releasing the results of the election. I agree that they should be released, and if somebody didn't do well, well, those are the results of the election. But the majority of the board has felt that, it may hamper people from running in the future, it may damage people's reputation, et cetera, et cetera. So, but I agree with your, yeah.
I think what the board was thinking at the time was, with a number of people running, it was kind of like, yeah, there's a right for transparency, but we don't embarrass anyone. People don't want to run thinking they're going to come in dead last. And, publishing that, and somebody who legitimately ran and wanted to be on it, and you got 17 votes, is very embarrassing. We wanted to prevent that. You can find out, like you said, well, I'm somewhere in the middle. That's in general where we want to leave it. We just didn't want to put the numbers out to the public. The individual board member who didn't win got a pretty good idea of where they were.
We'll look at that for the policy. Let's try to have it. Yeah, I think some of this happened. It did for me.
Kevin, you would want to know how you came in, right?
Absolutely. But I think it's not right. So let's keep rolling. I think we've covered that well, and I appreciate everyone's feedback. Let's roll into. We've got a couple more technical items here. This was raised by someone.
What's going to happen now with this issue?
We're gonna go back into the board and, meet on it.
Feels like it's gonna end up being a vote.
It's gonna be a vote.
Committee or board?
Board. The committee recommends, the board ultimately votes.
Phil,
No, I'm just, my thinking is, you probably know what it is that my thinking is that I think the task force and the board should talk together about this and benefit
I think we
from each
can do
other's
that.
knowledge.
We'll figure that out this weekend. All right, so I want to get into, we're up to, Article 4, Section 3, Board Member Elected Term. And I'm looking specifically, it's Section 3 and Section 6. One of the concerns that came up is once you pass these bylaws and it says elected terms are 3 years, does that mean Jerry is suddenly out immediately? We first started, David DiStefano had an opinion, and then we actually went to outside counsel. And so far, I guess what people have said is that if the rules were not in place when you started your term, they do not apply to you. That said, at the end of Section 6, we added, if this section was adopted during the term of elected director, then the section has no effect on that elected director until the elected director commences a new term. Very clear in Section 6. We did not put that language at the end of Section 3. I'm recommending that we did. I realize it's belt and suspenders, but this person raised that if it was in Section 6 and specifically left out of Section 3, it may cause confusion. So I'm going to recommend to the board that we add that to the bottom of Section 3. I know it's belt and suspenders. It's probably not technically necessary, but I think it keeps it clean.
Phil, were you guys okay with that?
I don't know if we discussed that or not.
Yeah, we did, and I think you made a good point that it's not technically required, but it's probably something that we could do. It doesn't hurt us.
Well, yeah, there's so many more issues around that.
Yes.
Yeah, I think you need to take a look at the rest of the document then, Kevin, and make sure now you've excluded it in 2 places, which I don't have a problem with conceptually, but I think now you need to look at the rest of the document and make sure that there's nothing else in there that would apply to existing directors that would be a problem. So I think you put this on the question for council, and I think it would be good to get their advice on this.
Yeah, I agree. We asked them to review it. So maybe they can make a global statement, like with respect to section this, that, the other, that we're specifically carving out the current. Again, my understanding is that's the way the law works, but I think as a member pointed out, it would be clearer if we delineated it. So then the next one is, this is also with outside counsel. It's Article 4, Section 5. And it was also some, this is about removing a director. Why does article, objections to removal of an elected director by the members may only take place at a meeting and may not take place by written consent or written or electronic ballot. So a lot of people raised this as an issue. They thought the board was trying to prevent themselves from being removed, make it harder for them to be removed. Obviously, in a meeting that required quorum on KICA, that's a near impossibility to get that many people together. We went back to council twice on this, and that is currently the way the South Carolina law reads.
I think the problem is the act itself is not very clearly written, and written consent is not defined in South Carolina law. There's some issues out there where it's used. So the question that we're wrestling with is, a proxy is not really written consent. A proxy is saying that I give my right to vote to Beth, who can then vote at the election. Written consent is somewhat different. That's why we're asking, kind of parsing this down to try to come up with a solution so that we can have a valid vote, enough folks involved to make a decision, because otherwise the whole idea is meaningless. And so it's just, part of the problem is the act is not clearly written, and therefore the covenants aren't clearly written.
I just want to, stepping back from that, that's a 2-part issue. The proxy, whether you can do this by proxy is the second issue. The community member that raised this, their actual concern was that if you thread through, it depends how you read one particular section of the statute. If you thread through it, it seems to at least open the possibility to have a director removal subject to electronic vote. And The issue is though, it's an unclear paragraph, and what I didn't realize at the time that I was responding to this earlier was that there's commentary that you'll find that goes with the statute. And the commentary makes it very clear that what that paragraph means is that you cannot have an electronic ballot regarding a director removal. It has to be done at a meeting. And then you get to the second issue is then our proxy, our proxies are restricted right now to quorum. The question is written consent, does written consent allow somebody to actually proxy their vote for this purpose to another member to be at a meeting? I know that's all very technical, but I just wanted the community member to understand that after looking at the notes to the statute that were prepared with it, it's very clear that you cannot, this is not subject to 708, and that member will know what that means.
And we've asked council to tell us whether we think a member could provide proxy to another member who will be there in person. And that's outstanding. Any further comments on that one? A couple of these that I had on my list, we already covered earlier. The next one was a member asked if we would be disclosing the conflicts of interest forms. All the staff, committee members, board, I think we covered that already. Yeah, with the other one. Protection of the removal of elected director, we covered. Article 6 we covered with Article 3. And the board. Yeah. Yes, that should have been my members. The title's wrong. They asked if we would, everyone fills out a conflict of interest form disclosing any conflicts they might have, whether we would make those publicly available. Right now, we do not. I'm going to bring that up with the board. We'll consider that in our policies, but as of today, those are not publicly released. All right, the next big favorite. No one has anything on that. Oh, please.
I guess my question on that, and I was talking to Ellen about that, was to fill it out, what I would think might be a conflict of interest. Somebody else might not think of it and not put it on. And so I guess a better check and balance for it to know that what was put down is really all the conflicts. Just because we might think differently on what is a conflict and what is not. So somehow to make sure that's clear, maybe making it more public is the way to do it so that people agree that that's a conflict or it's not a conflict.
Anyone else on conflict of interest forms? Okay, and I was jumping into Robert's Rules of Order. So I'll give some history of this. I'll let Phil speak to it. This has been in and out of the document a number of times. I think at one point we had Robert's Rules of Orders. We briefly had guided by Robert's Rules of Order. We then moved to guided but not bound by Robert's Rules of Order. And then eventually we pulled it out. I think rather than debate the language, I've tried to encourage people to think about it in this way. Are we encouraging and emphasizing Robert's Rules of Order in the way that we conduct our meetings, or are we making them a legal requirement? And I'll be the first to say, I did not want to make it a legal requirement. I'm fully in favor of running our meetings by Robert's Rules of Order, encouraging them, following them the best that we can. But I've seen so much litigation and so much ongoing disputes on this island that I think once you write, constrained, if you're constrained by, bound by, require Robert's Rules of Order, I think you make it a legal requirement. It worries me that we're basically putting 200 pages of Robert's Rules into our bylaws, and I worry that how our meetings will be conducted will not be in a professional, congenial manner, but it'll turn into a fight over the rules. So I think they should be encouraged, but I personally don't think they should be legally binding. Jill, do you want to?
And just when the board talked about this and talked about this and talked about this, our final unanimous agreement was to use them and put them in the policies, but not make them legally bound. So that was unanimous on the board and not on the task force.
On that point, we have another conversation on that. If the board adopts a policy that is adopted pursuant to the rules and regulations or the bylaws and everything.
It's more the procedures document, not a policy.
You have to be careful because how you do that may make it enforceable under the bylaws.
So that's why it was in the procedures.
Frank, the attorney, and I had a long discussion about that. But I was the one who kind of had a temper tantrum about the not bound by part. I frankly believe guided by is acceptable. And know some folks don't agree, but guided by means you will follow those rules. Not bound by means you might as well not even put it in there, which I think is why the board reacted and said, we're just going to take it out. Sure, the board voted never to talk about it again, but that's not going to happen. But one thing that Robert's Rules is a huge, thick document, and then there's a smaller, condensed version of it. But a fraction of that is really what applies to boards. And I've tried to find whether there's been litigation over somebody not following Robert's Rules. And I know you're right, Kevin, there's a lot of threats of litigation on the island, no question. But I can't see, because I haven't found examples where people sued because you didn't follow the exact requirements of Robert's Rules. And then in the midst of all this, I can't remember which attorney gave this to us, but it's Robert's Rules of Order cheat sheet for HOAs, essentially, recognizing that there's only a couple provisions in Robert's Rules that actually apply to how boards operate. I think a lot of us feel, and a lot of the folks outside feel, although I'm not speaking for them, that the way the board has operated recently, or in the most recent past, or however you want to frame it, Robert's Rules would have made a difference in terms of how the organization moved forward. And I think it's just having that structure behind you is important. I don't think you get sued. I can't guarantee that. I don't think it's going to mess things up. It's just going to make a more consistent operation of the board.
Online?
Yes, we have Jenny Bush. Jenny, you should be unmuted.
Do you hear me now?
Yes, Jenny?
Okay, I am in favor of Robert's Rules and would suggest the word to say the following. The current edition of Robert's Rules of Order, newly revised, shall be relied on for the conduct of board meetings to the extent to which they are not inconsistent with these bylaws or any special rules of order adopted by the board. I think that is a very benign and traditional way to rely on Robert's Rules for conducting orderly meetings. Remember that Robert's Rules have special, relaxed, more casual provisions for small boards, such as KICAs. So the formality that some people not familiar with Robert's Rules fear is not reality. There is no magic legal mumbo jumbo that has to be followed when making a motion or making an objection. Plain English will do, but it gives, if I, God forbid, were the chairman, I would embrace Robert's Rules because it gives me the backstop of saying, no, Joe, you can't speak again. You can't interrupt Susie. Susie has the floor. It gives me the backup so that I wouldn't be accused of being biased or arbitrary. I think it is a gift to the chair who's in charge of presiding over the meeting and maintaining order. And you can overrule any particular provision of Robert's Rules that don't seem appropriate for you. But I think say you'll rely on them, that doesn't make them have the force of laws. If anybody sued, it would be a frivolous suit, in my opinion. So I think it is a good thing to rely on Robert's Rules for the conduct of the meetings. That's all.
Jenny, would you be so kind as to send us that language that you initially started out with?
Yes, in fact, I already sent it to Kevin.
Oh, okay.
Kevin, it's in your email that I sent to you.
It wasn't in the last hour. If you could please resend, that'd be great.
Oh, that was several days ago when you and I were going back.
I know.
But
Yeah, I got it.
okay.
Ginny, I thought that was well thought out. And I think we're making progress on this issue.
Thanks.
Anyone else? Please, oh, yeah.
Well, in favor of Robert's rules of order, I think the board should have some kind of order. And let me go back to our $11,000 document again, where the second opinion states, board must follow Robert's rules. That's the second opinion, but I don't understand why, even after a second opinion, we had the governance task force recommended, the second opinion recommends it, and here we are thinking about, well, no, let's not have any rules at all. I don't agree.
So you're changing your opinion on this?
No, I always was.
But you agreed to put it in the procedure document with the rest of us, so are you changing your opinion?
I don't think she stated about putting in
No,
the
I'm asking-
procedure manual.
That's
I think it should be in, the bylaws. I mean, it's in the procedure manual. It won't, vote against it if it's in the procedure. If there's an agreement, it's going to be in the procedure. Because I think it's going to be, if it's in the procedure manual, I think, like Phil said, it'll apply to the bylaws. So, I mean, it'll be applied. So I have no problem.
But all I'm saying is, we all agreed to put it in the procedure manual. You're still okay with that, as long as we have it somewhere, is what you're saying?
Yes. Okay.
Beth, I agree to put it in procedure manual for reasons we've talked about a lot of these issues, because if we change the bylaws, we got to record a new document. So I think if we put it in a procedure manual and we'll see how it works, if it works fine, we don't have an issue. If it's a big problem with it and we want to change it, that means we'd have to change the bylaws, which is a whole other process. So I'm in favor of Robert's rule, whatever form, whether in brief or guided by, but I think for now they should be in the procedures manual to see how it works.
Right, so that's pretty much, that's what the board agreed to unanimously. So I was just trying to see if people have changed their position on
No,
it.
I don't.
Well,
And we didn't disagree with trying to use Robert's rules and trying to have them there. We all thought it would be helpful to us, but we didn't want them in the bylaws per se. We wanted them in the procedure manual as a procedure as to how to run our meetings. And when I listen to everybody, it is a little subjective. You don't have to use the big one, you can use the small one, then there's quick notes, then there's that. Ginny has good language there. It's all good for our procedures, governance procedures that we're all agreeing to do.
And I understand, well, I don't understand because we weren't part of the conversation.
Well, you just.
But we are now. And we are hearing what people are saying, although not all the board members are here.
This is far stronger on this one.
I firmly believe they should be in the bylaws. If you have them in the policy document, and the policy document is not formally adopted, it doesn't end up rolling into the bylaws, which we once again have to check on, they don't, suppose somebody doesn't follow them. And so is somebody really going to be paying attention to how it operates if it's not a requirement? That's why I think in the bylaws. And David, it's easy to change the bylaws. You're going to, I mean, what we're doing this time is a complete rewrite because we needed to. There's going to be more changes to the bylaws, I guarantee you, coming up, because as we're working through things and we start learning more how we adopt stuff, we'll probably change things, but it's not necessarily the same kind of process we've been going through. So I still firmly believe it should be in the bylaws.
Yeah, I think we're all dancing around the issue is how enforceable they are.
Yeah.
And I think they should be very, very strongly encouraged, but I think we take a risk when we make them legally binding. That's what I've been. So relied upon, to me, I'd have to go back to our council. Relied upon, to me, sounds a lot like guided by, and I think Jenny, maybe you could chime in, but if they're relied upon, can someone sue us to invalidate a vote because we made a mistake using Robert's rules during the term or exclaim they were excluded from a conversation? That's the primary thing I think we need to protect ourselves from.
Well, I agree with Jenny, that would be a frivolous suit at best.
You can make it frivolous? Yeah. That doesn't mean it won't happen. It doesn't cost us all an awful lot of money. Yes. All right. Okay. But
You're muted.
Uh, I just firmly disagree that relying on Robert's rules has the force of law and would lead to a colorable lawsuit. I've never heard of that happening. You can ask a South Carolina lawyer, of which I am not, gratefully, but I have never heard of a suit based on an infraction of Robert's rules. In the first place, the board can override Robert's rules. So if you chose not to follow them, I think you have in effect agreed to waive that rule. So you're not caught and painted into a corner.
Ginny, do you think they should be in the bylaws and not in the procedures manual?
Normally they are in the bylaws. I would prefer them in the bylaws, and I do not think that makes them any more legally risky than in the procedure manual.
But the board can waive saying in circumstances.
The board can, yes, the board can adopt a standing rule, a special rule, which is to say, if the occasion came up, you could essentially waive that rule for all times or for that particular occasion. They
Majority.
are
On a vote of the majority of the board.
I'm gonna move us on. I think I was trying to end this after 90 minutes. I think we're down to a couple straightforward issues. Thanks everyone for your time so far.
Kevin, I just have one more comment on that. I think the big concern we have for Robert's rules is the way we're running the meeting, not the result of the meeting. So, I mean, I just don't see, wherever we put this, I think is going to be okay. The board's going to have to decide how to do it. But I agree with Jenny. I don't see there's any way we're going to have any legal problems wherever this is.
So the next section I'm moving up to is Article 5, Section 8. This is a question. Can the board discuss any topic in an executive session? What can it vote on? So I'm looking over at Section 5. Yes, the board can discuss any topic. There's no, flip to it myself. There's no requirement that we restrict our conversations, but it can only vote and act on the, I think it's items A through F in Section 8. The next one was Article 5, Section 9, right behind it. This is actions by directors without a meeting. This had quite a bit of conversation as well. A lot of people felt that we shouldn't be taking actions without a meeting. But I want to point out, this is really, everything under this paragraph has to be unanimous. So at first it was limited to just time critical issues. And we realized that there are some administrative issues as well. Sometimes we've debated something in executive session or board meetings, then we were waiting for a few more things to be tightened up, and Shannon may send it around for a final vote. I don't think we've ever done anything major here, and especially because they're unanimous, the risk is very low. Any board member decides that they do not want it to be voted there can block that vote, but we did not limit it to time critical matters for that reason, that there are small administrative things that frankly, it's an undue burden to set up a meeting for that we would unanimously approve.
But the vote must be unanimous.
Unanimous.
And then it ratified at the next board meeting.
Yeah, I guess the question is, if it's administrative and not time critical, why can't it wait until the next meeting?
Well, I guess it's what you call time critical and how we use, I mean, if we have to, we used it last month we talked about insurance for a long time. We got the final quote in, we had the exact final number and we all approved it. Frankly, administratively, was that time critical?
No, that was time.
I guess you could call that time critical.
Your insurance is probably expiring, so that would make it time critical.
Shannon, can you think of any other examples of things that you call administrative but not time critical?
Off the top of my head, not really. You generally are doing like capital items that have gone bad and you have to replace an HVAC immediately, or that type of thing.
But that's your time issue too. I mean, that you need to replace that air conditioning with a sandcastle. Now people are going to die.
Here's the issue. Here's the issue and why that was in there. In the past several years, there's been now granted, it's not, it's not a unanimous requirement right now, but there's been abuse of this where the board has made decisions that are not time critical, that are politically controversial, and they've done it in these meetings. And I think all of you sitting there now should understand that by taking this out is not a loophole for that. And I understand, so.
Were those done unanimously? In your examples, were they all unanimous?
No.
I think that's, for me, the dividing line. If it's all 7 are on board, it's probably not a.
The unanimous, I think, changes the situation totally. Jim.
And that's why I didn't object to it, but I just want to be clear because a community member has brought this up, and I'm sort of on the fence on it, whether just given the behavior of the boards of the past several years, whether that's another curve that we need.
Yeah, but the unanimous was the issue there.
Right.
Go right ahead.
You just might want to consider changing the wording in that, because you say consent to taking such an action, and you took out unanimous vote, unanimous vote, and so that could be construed to you're taking an action, but the vote is not unanimous. That's the way I read it at first, and the first couple of times. So it's only now when you say it's a unanimous vote, but
it's not a vote. I'm sorry to interrupt, but just clarify that the way this is statutorily laid out, the issuing the consent to the action is itself a vote. It's a one-step process. So there's not a separate vote. It's unanimous consent. So if Shannon sends something around, the board will say, I'm in favor of this action. I consent to this action. And that is tantamount to a vote.
Might change that, Jim? I just have to say, I understand where Maria's coming from, because I had trouble just following that and understanding the process that we were supposed to be using here. Because first it was, we needed to be unanimous to even have a vote, and then we'd have a vote. So it was a two-step process, then we ratify it, which is the real vote. But I found this a little bit confusing. I couldn't follow it so easy until you just said it is the only time I actually followed what you intended to do here versus reading it.
Well, what I would say is you made that comment to us before, and I changed the language to make it, I thought, abundantly clear that it's a one-step process.
We'll we can probably add the word unanimous.
But yeah, that'll be in somebody else's hands to clarify it further. So.
Okay. I just kind of understand what she's saying.
Yeah.
That's all.
Yeah. If no one else has anything on that, I'm going to jump to, this goes back to Jim, but we only have 2 items left. Article 6, Section 2, where we talk about duties of the board. There was a comment that we should reference the South Carolina Homeowner Association, but Jim, I think you thought we already covered that under powers.
Yes, it's in Section 1. If you look at Section 1, which I'm scrolling to right now, you'll see that it says the board shall have the requisite power, duty, and authority to perform its obligations under the associated articles, association covenants, general covenants, these bylaws, the SCNC Act, which is defined as the nonprofit statute, and the SCHC Act, which is the Homeowners Association Act.
And then the last we might have duties of the board. There's a comment made that bylaws should address long-term strategic planning. That is something we're going to look at in the policies. We felt it was more appropriate there than in these bylaws. We heard the comment, we've written it down, we understand. I think it's a good idea, but not necessarily directly in the bylaws.
You mean the procedures, not the policy.
I'm sorry, procedures.
Yeah, there is a strategic plan on the website. It's not as refined as I think Paul was talking about, but you already do have a strategic plan process.
Yeah, it's something we should probably revisit from time to time. So I'll open it back up to anyone online or in the room with further comments or questions.
Thank you very much.
Great. Thank you for your time today. Appreciate the interest.
Well, can you tell us? Okay, I'm next. Where?
I was going to talk about it on Monday, but I think it's really up to the board. I'm going to send around another list of everything, the feedback we got today. I think some of these things will go away. They're administrative items like that the board will handle. There's a couple big ones like Robert's rules and term limits that we need to either have a separate board meeting on, or we need to handle the board meeting, or decide what to do next. I'm wide open, and I'll defer to the chairman on the board's time.
So we have a couple things we need legal opinion back.
Yeah, it won't happen.
Right, and then there's no meeting in August, just to get everybody's time in their minds, the timetable we're dealing with.
Postponing this now to September, you're saying?
Well, we need legal counsel, that's not gonna come back. As a board, we have just two issues we have to,
It is.
debate, that's all. We can debate those issues ourselves on Monday, right, and have our part done, but the legal counsel.
When are we trying to get legal opinions, so.
You know, I sent him,
Someone in here.
I sent him a detailed email that the committee helped me with yesterday, I think it was. I'm not sure if he's in or not. I was gonna give him 24, 48 hours before I started pestering him. But, you know,
He's pretty quick.
he's usually pretty quick, and he sends very detailed answers. Like I found when I write something out in detail, he writes us back very detailed, like we did on the removal issue. It's possible he could send it back today and we could have a really in-depth talk this week. And I think at least one other issue came up today for outside counsel. So I don't see us having, we can debate more issues and get them off the list. I would love to do on Monday, but I don't think we'll have a final draft with council review until after Monday. We can have a special meeting of the board later in July or August.
This thing has been hanging around for, I mean, we're gonna wait till September.
I
and
just
We're gonna
threw
come
out
up with
the-
other, we're gonna come up with another legal opinion.
Alice, I just threw out the time frame we're dealing with. And
No,
we
I
have
hear
to
you, but
figure
I mean,
out our steps
we've
to try
been
to-
talking this for now months and months and months. Is, you get.
But the issues we're raising now with the legal counsel are getting to be really, really tied to issues that we missed. I mean, just because we're looking at it in larger.
You know, I'd rather have a document that we've all been very careful with, that the community has looked at and talked to us about, that we can all vote on it and get to the right place.
If we're looking for a perfect document, we're never gonna get there. We're getting close. We're gonna get it. We're gonna get September, somebody's gonna come up with another one,
We're down to like 8 items. Several are with the legal counsel, which will get answers on. And there's two issues the board has to just decide what we want to do. Robert's rules and term limits. And we've gotten all the feedback, and we can have that discussion on Monday and finish our part off. At our executive session, we can do that if we want.
Well, can we hear on Monday when the legal opinions are coming back, Kevin? I mean, or
I'll try.
at that time?
I'll try. I'll call him again, but I don't control him, so he may be on vacation this week.
I see no reason to get this done without having the due process and that, as someone alluded to, making sure that we've crossed all the Ts and dotted the Is, and there's no rush that's been put on this. It's much more about getting it right and making sure, and I don't think 1 month will make any difference whatsoever. Let's just make sure we get it right.
Yes,
I just want to say,
we appointed 2 board members in 1 board meeting in an hour, okay? Without any, anything constrained, let's look at this again or whatever. Now, here we are 6 months into this and we're still saying, let's do this perfectly, let's do this right.
Have we made great progress? I would say yes.
I just want to say, I know this has been frustrating for the task force. I think the task force has done a great job. I've relied on so much, and I've learned so much from the task force in helping me get through these. And I just want to again say thank you. Thank you. I look forward to continuing whatever work we have to do together.
Thanks, Alan.
I think one of the things we can do on Monday is schedule a meeting to finish this. There's no reason we have to wait till September. That's 2 months from now. We deserve to get this done. We'll have a special meeting, I hope, in August to finish this off, just to focus on this, rather than clouding it up.
I will be going.
A lot of other issues in September. We don't need September. We got a 2-month gap. We're gonna have a lot of routine things in September. Let's have a special meeting, maybe 2 if necessary, and get this done.
We will see. Okay, thank you.